Good afternoon, all. This pre-trial review is in the matter of CFI 070-2022 before His Excellency Justice Lord Angus Glennie. The claimant is represented by KBH Limited. Lead counsel is Mr. Richard Hill, KC. The defendant is represented by Davidson & Co. Lead counsel is Mr. Andrew Trotter. Thank you, Your Honour.
Yes, thank you. Can I apologise to the parties for keeping them waiting? It's probably we moved rooms and somehow things went wrong. There we are.
It's no problem at all, Your Honour. This, as you know, is the PTR in this action. I, on behalf of the claimant, have circulated a short agenda for this hearing within our supplemental note, which I hope the court received today.
Yes, I did.
I'm grateful. So there are four items on the agenda. The first three can be taken very quickly. They are defendant's document production, second, confidentiality regime, third, timetable for trial, and then fourth, directions following the court's existing direction in respect of a jurisdiction challenge. And I propose to take them in that order. Starting then with the defendant's document production.
Your Honour, I hesitate to interrupt, but there is a preliminary matter which will, of course, affect all of those agenda items. If your Lordship is inclined to hear me on the direction,
I don't accept.
My learned friend won't accept that, of course, but I wanted to ventilate that at the outset.
Yes. Well, should we just? I don't think it affects the first three items. The first two items, does it?
No. It doesn't affect defendant's document production at all, which is the first item.
Well,
so I suggest we move on.
Let's not fall out over it. Mr. Trotter, what is your problem with the first two items?
My Lord, it's right that the first two items don't turn on the direction, and it's also right that they can be dealt with in very short order, because I think they are already agreed, or very close to agreed. So I'm content with that, but I'm concerned about running down time.
Yeah, but if those first two items are subject of significant agreement, then can we just not deal with them very quickly and get them wrapped up?
I should hope so, my Lord.
So,
I'm grateful. Starting with defendant's document production, you have seen what we say about this at section C of our skeleton, and how matters were developed in correspondence leading to Sunday's revelation of quite significant disclosure failings. I'm not going to go back into that because of the time, but you saw the key points summarised at paragraph 18 of our letter. In our skeleton, we propose three directions, which are at paragraph 21 of our skeleton, which you have.
Hold on.
And it's at L tab 6, page 9.
Paragraph what of your skeleton?
Paragraph 21 of our skeleton.
Yeah.
With three directions. Now, as I understand it, those are agreed, save in relation to the third item, which is a witness statement from Mr. Gupta, where we had suggested 19th of September. Defendants want until 26th of September. Ultimately, this is a matter for Your Honour. For our part, we can't see why this cannot now be done within 7 days. We're in the court's hands. You've had a development today to suggest that.
Is there any reason not to split the difference?
We would be content with that.
I think that's probably fine. The concern is logistical in that there's a hearing in which some key personnel are involved next Friday. So setting the deadline on that day would be very difficult. It's also that all of the work streams interact, so it'd be sensible for it to be on the same day. But if you're inclined to split the difference,
that's the following
then
Tuesday.
I won't say anything further.
What is the following
Tuesday? 19th is a Friday, is it?
Yes.
So yes.
What's the Tuesday following?
23rd.
23rd. So should we say 23rd?
Yes, I'm grateful. That's then that item. Next item is the confidentiality regime. Again, this can be dealt with very quickly.
Yeah.
The defendants have proposed maybe an interim regime for dealing with this. It's still unclear, and it essentially involves a further designation process of extracts which are really considered to be, if you like, particularly confidential or sensitive. We're happy with that as an interim measure, but we are a little unclear about what the defendants say should happen at trial if these documents are to be referred to. We've written to them a couple of days ago asking whether it's going to be their proposal that matters get heard in private insofar as they relate to those documents. We haven't had a response to that. And so while this is unclear, what we suggest is that we go with the defendant's approach and their proposed directions on this for now, which is a modification of the confidentiality regime. But we build in both, one, an express liberty to apply, and two, an express provision for the court to give further directions at or prior to trial with regard to the treatment of any documents that are designated in this further confidential capacity. And again, I hope that's uncontroversial.
Is that right with you, Mr. Trotter?
I don't see that that's controversial, my lord. We can pick up between the parties the issue of how the details of that is to be dealt with, and I think it should be capable of being resolved without troubling the court.
If we include in the order that's going to follow from this something along the lines that Mr. Hill indicated with those extra qualifications, you're happy with that? Mr. Trotter?
Yes, my lord, yes.
Very well, thank you.
I'm grateful. There's then timetable, that's provisionally agreed, and this may affect from Mr. Trotter's argument. I'll just flag it up now. It's at L9, the timetable. The provisional timetable anyway, so it doesn't need to be settled at this PTR. And at our end, we've already spotted a mistake in it, in that it slots in an extra day of evidence, in fact, after expert evidence rather than before it. So that needs
I noticed that. Yeah.
So that needs adjustment. But also the length on day one of the opening submissions may be affected by the debate we're about to have, because
I expect so, yeah. But should we leave timetable for the moment and go to the substance of what's going to happen about the jurisdiction challenge?
That's right. And our position, and you asked for our party's position on directions that should follow. Our position is that your direction that you've already made was exactly the right one. And the direction
I should just say, it came out as a direction. It was meant as a sort of weighted suggestion.
Yes, well, I'm happy to treat it as that. We suggest that it's exactly right, and that the directions that should follow are, one, that direction should be confirmed, or that should be confirmed as a direction. Two, Mr. Gupta should file his defence within 7 days. It's
so advised.
If so advised, exactly. And he's had the pleading since June and should be able to manage this, and he's clearly not short of resources. Next, we should then have 14 days for reply. And we're, of course, happy with an express recital, which records our confirmation that his filing a defence is without prejudice to his jurisdiction challenge. So he's not prejudiced in that respect. And we suggest that's all the court needs to do at this hearing. We do oppose the suggestion that the court should not direct the jurisdiction challenge to come on at the beginning of a trial. And I make a number of points in that context. First, in respect of the application itself and the approach the court should take to it generally. And secondly, why procedurally the court's direction is the right one and the claimant's arguments to the contrary are not right. So the first relevant point of context to the application is that the jurisdiction application is, we suggest, abusive for two reasons. First, it's abusive.
Well, if we go into the question of each one calling the other side's arguments abusive and unfounded and whatever, we're not going to make any progress.
Well, I don't want to get hung up on adjectives.
Well, the awful lot of paper has been used so far on adjectives on both sides.
Yes, well, I'm happy to use unmeritorious in the sense that the punchline is this is not leading to an application that the court is going to take an extensive time to dispose of. and it can be dealt with quickly. And the point that I make, and the reason I use the word abusive, is because of the way the application has come about, which is that we had a contested joinder and amendment application in July, in which
I know the history.
Yes, in which, and those, of course, were defendants to that application who, where Mr. Gupta was the sole director of those defendants, and we're talking about at the moment the existing legal team. And if there's anything in the points raised as the appropriateness of a joinder of Mr. Gupta, one would expect those points to have been taken then, rather than what we've seen, which is the jurisdiction application held back and made at the last possible moment, and then made in a way that it seems calculated to disrupt the trial. And we suggest that that behaviour in litigation is itself a factor to be taken into account. Secondly, the application lacks merit because it is replete with points that it's very clear on the authorities are not even open to the defendants to run. And I'll just come on to the detail of that now, because it covers my next point, which is that the application has extensive submission as to the merits of the amendments and the substantive case against Mr. Gupta. And all of that material is irrelevant and shouldn't be introduced on an application of this kind because it's directly contrary to Court of Appeal authority, including Court of Appeal authority in this litigation. And I've
Can you just help me on this? I've read your contention that it's almost either all or almost all merit-based attack on the joinder. But is there any part of it which raises a discrete point of law which is not, as it were, an attack on the merits?
Yes, I'm going to come on to that. There is one set of arguments that are framed as going to the gateway, and that we would accept that in principle, if there are a sound argument of principle that went to gateway, that is open to the court to consider on an application. And I'm going to come to that very shortly. But before
is that the argument that it's better should be better heard in England and somewhere else?
No, that's forum non-convenience. That's one of the arguments which I suggest can be dealt with extremely quickly. So if I could just list the arguments. So one, we've got arguments on the merits which go to serious issue to be tried. And that we suggest is directly contrary to Court of Appeal authority. And the court will take no time disposing of it. And there's no answer to that. Next, there are extensive allegations based on what's said to be a failure of full and frank disclosure at the joinder application. And that's simply misconceived because, and this is a point the defendants themselves rely on, the parties to the joinder application were the existing defendants. And that application was on notice, fully argued. And even if it could be said Mr. Gupta's position was in some way relevant, he, through his existing lawyers, was well aware of that application too and could have attended and joined himself to the joinder application had he chosen to.
Yeah.
Next is the forum non-convenience point, which you just mentioned, Your Honour. Those are, we suggest, also so lacking in merit the court can dispose of them extremely quickly. Amongst other things, we have here a trial of allegations already made involving Mr. Gupta, in which he's already addressing as a witness, and they arise in the existing litigation between.
Yeah, I have that point.
And so there could hardly be a clearer example of an appropriate forum. So that leaves the one arguable point that is relevant to jurisdiction, which are the points going to the Article 14 gateway. But we suggest that when you analyse the points made, there's no realistic case there either. And
the Article 14 gateway, is that what we call a necessary and proper party?
That's right. So you've got to have a jurisdictional gateway, and one of them is a joinder that's happened. This is the Nest investment case. One of the possible gateways is a joinder under RDC 20.7. Now, we've addressed all this in paragraph 24 of our main skeleton, and there are a number of subpoints. The first
paragraph what of your skeleton?
Paragraph 24 of our main skeleton. Sorry.
Hold on a second.
Sorry, I'm sorry, that's the wrong reference. Paragraph 24 of the defendant skeleton is where they address the gateway arguments. L tab 7, page 8. So that's their list of points in relation to gateway.
Yeah.
And the starting point is that the defendants themselves concede that where the DFC court orders a person to be added as a party under RDC 20.7, then that itself confers jurisdiction. That's the Nest Investments case. And that's expressly conceded, just so you have the reference, at paragraph 94 of Mr. Davidson's witness statement, at bundle G, tab 63, page 39. So one might have thought that having made that concession, that's really the end of the matter. Mr. Gupta has been joined and the court has jurisdiction. And so what has happened here is that the defendants now base their arguments on an attempt to re-argue the question of whether it was indeed desirable or appropriate to order the joinder of Mr. Gupta. In other words, the argument that was held in June. Now, it's worth noting there's been no appeal of that order, but it's also worth noting we're now at the jurisdiction stage. So the only question is whether we have a good arguable case in relation to the gateway. And we've given the authorities for that at paragraph 4 of our supplemental note. And none of the defendants' arguments come close to establishing the contrary. So just running through the points the defendants make at paragraph 24 of their skeleton, the first one is on limitation. And that's a bad point for reasons that we develop in the supplemental note. Any dispute on limitation is a matter for trial, not for a jurisdiction challenge. And when we get to trial, the defendant's limitation point doesn't run at all. Because as we explain at paragraph 6 of our note, the relevant question is when there was knowledge of the injury and the identity of the person responsible for it. In our case against Mr. Gupta, yes, rise in document production and evidence in this case. So plainly, we are well within limitation period. And in terms of whether we have a good arguable case in that regard, we are, in my submission, a very long way the right side of a line. And we also, as it happens, have subsidiary limitation arguments, if we need them, that we identify in our supplemental notes for paragraph 6. And as I say, then this limitation argument is always one for trial. Limitation often has a factual dimension, and it can't be suggested that we don't have a good arguable case, which is sufficient to confirm the joinder or not give rise to a challenge for the joinder for the purposes of a jurisdiction challenge. So that's the limitation point. The next point is the suggestion that it's not desirable to join Mr. Gupta because the case against him arises in the alternative. And there's no authority whatsoever for that proposition, and it's an illogical one. The defendants, through the evidence of Mr. Gupta, have advanced a case in the litigation which we say leads to the consequences that Mr. Gupta is personally liable. And it's entirely fitting that he's joined so that the liability bites on him. And the correct approach to the exercise of RDC 20.7 is that set out in the Malawi against Hibbert case, which I referred you to at the joinder application. The court considered it there. And as you recall, the test can be in the form of an overlap of factual evidence between the existing proceedings and the new party, or in some cases, the new party can be concerned with the outcome in such a way that it's desirable. So it's quite a one.
Bear in mind, we're not arguing the points fully now, so I've got the point.
And that's quite right, because again, did we have a good arguable case on that? Plainly we did, and indeed it was the right order to make. The third point is the suggestion the amendments are made late. There's nothing in this. The lateness is explicable because we rely on Mr. Gupta's own evidence and document production, which was only recently served.
I don't know what Kwasuling is.
Yes, well, I'll allow Mr. Trotter to develop that if he wants to, but it's not late in any relevant sense for the reasons we said. The fourth point is that it's an odd point, but there's been what they say a compounding of joinder of necessary and proper parties. That's difficult even to understand, because our point is that the claims against Mr. Gupta are desirable in connection with the primary case in relation to the agreement with the first defendant, which is the DIFC entities. So it's a wrong point. The fifth point made is that there's no arguable case against what's said to be the anchor defendants. So it's merits points relating to the underlying claims against the existing defendants. And we suggest that is beyond hopeless in an application of this kind. There's been no application to strike out on the merits, and that just as the court won't go into the merits of the underlying claim against Mr. Gupta, even less will it go into the merits of the underlying claims against the other defendants on an application of this kind.
Right.
The sixth point is just a more general assertion that the joinder of Mr. Gupta is otherwise not desirable, but the court's considered this question and rightly held that joinder is desirable. And so those are the only points that the defendants have come up with, which go to the gateway jurisdiction question, and we do submit that none of them have substance. So against that background, we do suggest that the idea that there's anything in Mr. Gupta's jurisdiction challenge that requires 4 days, or indeed any material amount of court time ahead of a trial, is quite wrong. The application can comfortably be addressed at the beginning of trial. It needn't occasion any disruption to the trial, and at most it's a small part of the submissions that will be made.
It could even be what I had in mind with what's been called my direction. I didn't necessarily mean to be decided at the beginning of the trial, just after all the evidence is heard.
Well, it may be best that it's dealt with at the beginning, for just so that it's out of the way, and Mr. Gupta can be clear whether he's participating in the trial or not, with his application, we hope, being dismissed.
The other thing that occurred to me this morning when I read your supplementary note was whether, instead of postponing it to the trial, the question could be dealt with without a hearing this coming week.
Without a hearing?
Without a hearing.
Yes, well,
on the basis of written we've got enough writing already, but on the basis of any further skeleton argument that anyone wanted to lodge by, say, Tuesday or Wednesday.
Yes, that's possible. We would be content with that. There's another alternative, which is that the court could have a short hearing of some kind in the interim. And again, in relation to both of those, the court, in fact, has jurisdiction just to dismiss the application summarily. And we dealt with an instance where that happened in the Barclays and Afra case, and we've given the authorities in the bundle at L 28.1. So the court does have a wide discretion how to deal with it. And these are all options: beginning of trial, on paper, or with some short. We suggest no more than half a day is required. Some short hearing.
What was the name of that case?
Barclays against Afra, and it's at bundle L tab 28.1.
Is it referred to in your note?
It's referred to in our supplemental note, yes. And in our main skeleton. So can I just mention the technical procedural points that the claimants run? And we suggest they don't have substance. The first is a point based on RDC 12.10, which is effectively says that the defendant need not file a defence before the hearing of the application. That is highly technical. If one needs an answer, the answer is that this hearing can itself be treated as a hearing of the application, as indeed could the court's earlier consideration of the application. So there has already been a sufficient hearing for the purposes of that rule, and the court in its case management powers can now go on to direct filing of a defence, of course, without prejudice to continuing jurisdiction challenge. So that is not.
But there's no obligation on, assuming I was with you, there's no obligation on Mr. Gupta to file a defence.
Quite. Exactly. And I completely agree that if so advised should go into the wording of any order. The next point is at RDC 12.8, which relates to a new acknowledgement of service after a failed jurisdiction challenge. And again, the short answer to this is that the court can abridge time under its case management powers so that this can happen. There are then the only other point of any substance raised procedurally is it said, well, the trial shouldn't be treated as a hearing of a jurisdiction challenge. And on that, we agree that one of the fundamental flaws of a jurisdiction challenge is that it trespasses onto areas which are matters for trial. But there's no difficulty with the trial being the venue at which the court dismisses the challenge, including dismissing it on the basis that it impermissibly seeks to run merits points. So we do suggest that technical procedural points aren't good ones. And the same applies to the points which are said to, where it said there's unfairness. So what's suggested is that there may need to be a need for separate legal representation, and that's a point on conflict. We've addressed that in our supplemental note. There's been no real explanation or flesh put on the bones of the assertion that there may be a conflict. It's not at all clear that the conflict arises. And as matters stand, if it really is the case, there might be some conflict, which even Mr. Davidson seems unclear about on his evidence. There's no reason to think that that can't be dealt with amongst the 3-member council team that's been working on this case over the last few months. One of them can be allocated to represent Mr. Gupta solely in relation to whatever the narrow issues are where this conflict might arise, if it does. The defendants also say that there are problems with other interlocutory steps in relation to pleadings or disclosure or witness evidence. Well, that's not right. Pleadings can easily happen and can happen without prejudice to the jurisdiction challenge. And there's no need for document production because that's happened already, and Mr. Gupta is a custodian. And there's also no need for witness evidence because we've already got witness evidence on the relevant points. And then the claimants finally say that the court's direction amounts to a refusal to hear the application. But that's a bad point because the court's always entitled to hear the application summarily. It can do that now, it could do that at the start of a trial. And however it's dealt with, there's no refusal to hear the application, it will be heard. And what the defendant's argument really boils down to is a complaint that the court isn't allocating 4 days of time to hear an unmeritorious jurisdiction submission. And the court in this court's never going to allow 4 days of time for an application of this kind. And a summary short determination is exactly what's required. So putting all that together, we do submit there's no objection of any substance to the existing firm suggestion that should in our submission stand, but we do accept alternatives of, as you say, a paper determination or some short hearing in the next 2 to 3 weeks.
Yes, thank you.
I'm grateful.
Mr. Trotter, you've been commendably silent. You want to speak?
Lord. I'm doing my best. My Lord friend spent quite a good deal of his submissions addressing the substance of the jurisdiction application. Today is, of course, not the occasion for that. If your Lordship is inclined to take into account what your Lordship perceives to be the merits of the application in making the case management decision, then I will address those issues at the end. But what I propose to do is to address the issue of case management first. And in that regard, there are really 3 points that I need to make. The first is about why it is that an unconventional course should be required at all. We say the only reason that the court should even or is even contemplating a course out of the ordinary is because the decision to join Mr. Gupta was made at a very late stage in proceedings. And that choice was made by the claimant. Now, the answer to that your Lordship has had today, and the answer that your Lordship had at the joinder hearing was that this all arose out of the disclosure and out of Mr. Gupta's own witness statement, and so it couldn't be avoided. But my Lord, that is, I'm afraid, patently wrong. Now, can I start by showing your Lordship what is said by my learned friend, starting with his supplemental note from this morning. If your Lordship has that, it's at page 7. paragraph 7. Where he starts by saying, second, the defendants have gone to great lengths to try to blame the claimant for the timing. And then in particular, paragraph 7.1, we have this, the claim against Mr. Gupta, the repeated suggestion that by the defendants that the claim against Mr. Gupta could have been brought at any time since the proceedings is wrong. As repeatedly explained since the joinder application was issued, the claims against Mr. Gupta arise out of the first and second defendants' document production and Mr. Gupta's own evidence for trial. They could not have been brought any sooner than that. And my lord, that reflects the same thing that we see in the skeleton argument for the joinder application. If we could bring that up on Opus, is at G58, page 6.
Well, I've got in a position where I'm in a different room and the documents aren't working very well. So you just tell me what it says.
Oh, I see. I'll read it out, my lord. It's paragraph 11 for my learned friend's benefit at the bottom of that page. And it says this: the third amendment is the proposed claim against Mr. Gupta. It has arisen directly following and as a result of the defendant's document production and factual witness statements. Now, my lord, this is misleading in two respects. First, that the allegations could have been, and in fact were, made sooner than the document production and Mr. Gupta's witness statement. And second, that the application was not brought, quote, directly following the disclosure and evidence, or indeed for many months after the disclosure and evidence. And can I just make that point good? If we go over the page in the skeleton argument, I'm not sure if your lordship has this on the screen or not.
I don't, but I'm listening.
Okay, so the document production that my learned friend says gave rise to all of this is 2 emails sent from Ms. Timms to Mr. Gupta. Those are the documents which your lordship was told at the joinder application gave rise to this revelation. And what is said specifically in paragraph 12 of that skeleton argument is this, and these are important words: against the background of those documents and admissions, the claimant is now able to plead a positive case in deceit against Mr. Gupta. Now, that's important for various reasons. For the present purposes, it's important for case management reasons, but of course the phrase able to plead a case also brings to mind the authorities about knowledge and limitation, and my learned friend relied on it for that purpose as well. But for case management purposes, your lordship's being told that the reason why a new defendant is only being brought in at this late stage is because he was only able to make this allegation as a result of the document production and Mr. Gupta's own witness statement. Now, that is, I'm afraid, nonsense. And I want to start with the pleaded case in my learned friend's
Mr. Claim. I don't want to stop you, but where is this taking me? I can understand your concern that Mr. Gupta was joined late. In a sense, it doesn't terribly matter for court management purposes, case management purposes, whose fault that was.
Well, my lord, in my submission, it matters a great deal, because what's being proposed is a case management solution which will result in significant prejudice to Mr. Gupta for reasons that I'll explain. And if the reason why that prejudice is being suggested is that the claims have been brought at a late stage and for no good reason at all, then there is no reason why Mr. Gupta should have to bear the burden of that choice and of that delay. And to put it very briefly, the position is this: the same allegations on which my learned friend relies have been an issue on the amended particulars of claim since November 2023. And the documents on which he relies were disclosed in November 2024 and January 2025. Now, the joinder application was not even brought until the 11th of June 2025. That is some 7 months after what he says is the smoking gun document that made him able to plead the present case. Now, given that delay, there is no reason for a departure from the ordinary course that a defendant is entitled to when brought in to a case for the first time. Now, I can make that good and go into all of the documents if that's going to be disputed, but it may be that that's not necessary. It might be worth taking your lordship. I'm not sure if your lordship has access to the documents at all, or whether.
No, assume not. I've got access to the recent submissions and affidavits and so on.
Understand. Well, I'll give the opus references for the benefit of everyone else in hearing anyway. My lord, not only were the documents disclosed a very long time ago, but in addition, KBH specifically analysed those documents because Mr. Kahlon, the claimant, in his trial witness statement, makes all of the same allegations based on all of the same documents in an argumentative passage of that witness statement. So the references are H/1/78.
Right.
So the first document relied upon is at paragraph 402.
Mm-hmm.
Now that document is merely a document where Ms. Timms quotes part of the first 5th of September letter. So that document doesn't itself tell us anything at all. The crux of my learned friend's case really comes out of the second document, which we find at page 44 of the same witness statement, H/1/44.
Yeah.
And at paragraph 210, we have the claimant in his trial witness statement quoting the document, the key document on which my learned friend relies, where Ms. Timms says, "I have modified the agreement to remove the bonus and LTIP, so I'll get a Dubai contract together based on the attached." Those are the words that are said to have triggered these new claims. Then at paragraph 212, we have the allegation that Ms. Timms altered the document. And at paragraph 213, we have the allegation that that was deliberate. And then over the page at paragraph 214, so at the very top of the next page, bottom of paragraph 213, it's alleged, and that's something that Mr. Gupta was aware of and allowed. And then similarly, the allegation in paragraph 214, he notes that the defendants now rely on the second 5th of September letter. And then at the end of the paragraph, he alleges that this is something that the modification of that letter is something that Mr. Gupta was party to. Now, of course, none of this is evidence at all, because Mr. Kahlon wasn't party to any of these communications at the time. It's purely argument by Mr. Kahlon on the documents in his trial witness statement, but it is the same argument that has been made in the re-amended particulars of claim when Mr. Gupta was joined. Now, Mr. Kahlon's witness statement was made on the 26th of February 2025. It was based on this document, which was disclosed in November 2024, and it reflects exactly the same allegations that were pleaded back in November 2023. So there is no reason why this hasn't been done a very long time ago. And the fact that it's being done at the last minute is a matter entirely of the claimant's making. Now,
given we
my lord,
got to a decision, to a joined a decision in July, I think it was 17th, 7th.
my lord, I think the hearing was on the 15th, and your lordship's order was sealed on the 17th.
Yeah. Your client, Mr. Gupta, has taken. He's perfectly entitled to. He's taken to the last minute with the steps of notice of intention to defend and then jurisdiction application.
Well, my lord, as your lordship says, he is entitled to do that. The issues that needed to be considered for the purposes of that application were complex. My learned friend says that there's nothing to them, but we don't accept that for a moment, and I can deal with that if necessary, but your lordship's obviously not in a position to resolve them today. And there's certainly nothing abusive about a new party who's been brought into the litigation taking the time permitted to him under the rules in order to exercise his rights. Now, my learned friend says, well, he's the director of the companies, or he was a witness in the litigation. My submission that cannot make one iota of difference. If it matters, then Mr. Davidson has given evidence about the extent of Mr. Gupta's involvement in this litigation so far. And it bears emphasis that Mr. Gupta is the head of a global steel business who doesn't do a lot of primary drafting anymore. And so he was not, this is not a case where he was simply the one-man company standing behind all of the instruction being given on every detail of this litigation. In fact, very far from it. And so it'd be quite wrong to say that the fact that Mr. Gupta has taken the time available to him under the rules should be held against him in considering how his jurisdiction challenge is to be managed. Now, my lord, what we say is the really going on here. One has to ask oneself, why on earth, given that all of these allegations have been in issue for years, was the decision made at the very last minute to bring Mr. Gupta in? What was it that motivated this very late stage play? And my lord, the answer became apparent to us very quickly after Mr. Gupta was joined. And we see it in KBH's letter of the 21st of July, 2025, which is at K/880 of the bundle. I appreciate your lordship won't have this, so again...
No, I do actually have.
Oh, excellent.
K what?
So the letter is dated the 21st of July, which is only 4 days after the date of your lordship's order, and it's before Mr. Gupta is even served. If we go over to page 2...
So what tab is it in the bundle?
Oh, I'm so sorry. It's K/880.
You carry on. I may or may not get it.
Thank you, my lord. I'll read it out anyway. So at paragraph 4, it said this: as a result of the joinder of Mr. Gupta personally as a party to these proceedings, Mr. Gupta, we're particularly concerned, it said, will now take steps to dissipate assets, whether belonging to him personally or to your clients, in order to frustrate any judgment obtained against him and or your clients. And I pause to recall, as your lordship may recall, that this has been something of a pattern in this litigation, and that KBH have had quite an ambition since quite a long time ago to manufacture a basis for a freezing order.
Can you read the rest of the paragraph, please?
The rest of the paragraph says, those concerns have been vindicated in the light of the information recently obtained about attempts to liquidate assets. And then there's listed below 4 properties, and it's alleged Mr. Gupta is suddenly selling these 4 properties. And then at paragraph 5, KBH say, our client is now actively preparing to issue an application for a freezing injunction against Mr. Gupta. Now, this letter is sent before Mr. Gupta is even served and only days after the hearing of the joinder application. So, my lord, what's really going on here is that the claimant or a clever lawyer at KBH has picked up on the fact that a house is being sold. There's been a brainwave they've thought, let's cobble together a claim against Mr. Gupta. Maybe we can get a freezing order. Maybe that will apply some pressure. Never mind that the modus operandi of this fraud was actually a crystal clear one-page document that was never concealed from anyone. And no doubt Mr. Kahlon was advised about the implausibility of the whole thing and decided to take this aggressive and belated course anyway. Now, Davidson and co have written back to try and put this zany plan to bed, and that letter is at K/889.
889.
Yes, my lord.
Right.
And in particular, the letter points out at some length the fact that some 9 months has passed since the last attempt to dredge up a basis for a freezing order. But the point in relation to these properties then comes on page 4. And it's paragraph 15 in particular that I'm interested in.
Mm-hmm.
Once again, there is no basis for these allegations. Of the 4 properties that you list, 3 of them are not for sale. The only of the 4 properties which is for sale is the property at K32. And then the explanation is given for why that is, and it has nothing to do with the claim because the real estate agent was instructed 5 months earlier. And the reason it's being sold is because Mr. Gupta is moving to Australia. And so there is nothing to see here. Unfortunately, it's all come to nothing, and we have heard nothing from them since. But my lord, we asked KBH to confirm that the application has now been abandoned, and no such confirmation has been forthcoming.
Right.
So 3 things out of this. 1, the claims against Mr. Gupta could have been brought at any time, as long ago as November 2023. But even if my learned friend is right about the disclosure, then that is November last year. And all Mr. Gupta's witness statement does is discuss those documents and say he can't remember. Second, right. The real reason this has happened is an entirely tactical ploy. And third, related to case management issues, it appears that the claimant is still holding this possibility over Mr. Gupta's head. So we wait to see if that will re-emerge after this hearing. So, my lord, in those circumstances, there is really no justification for taking any course that thrusts any prejudice onto Mr. Gupta. And can I deal then with that prejudice, which is my second point? Now, when your lordship gave the direction or made the proposal for submissions, your lordship quite rightly noted that relevant to that issue is whether there would be prejudice to Mr. Gupta as a result, and in particular, the fact that he is presently represented by common legal representatives. Now, your lordship could not have known, of course, that a few hours before that email came from the registry, we had written to KBH about this very topic. And I want to point that out in case it's suggested that this is some sort of recent invention or some similar such adjective. And that letter is at K/971. This is our proactive proposal as to how the case should be managed in the light of Mr. Gupta's late joinder. But the point specifically that I'm interested in at the moment comes at page 7 of this letter, at paragraph 28.
Yeah.
Where Davidson and Co. explain it's not certain whether our firm would continue acting for Mr. Gupta if the jurisdiction challenge is dismissed and the claims against both Mr. Gupta and the Liberty defendants are to proceed to trial. Now, this, in the light of the direction This has been explained in more detail by Mr. Davidson in Mr. Davidson's second witness statement. I'm not sure, has Your Lordship had a chance to read that witness
Yes,
statement?
I read it last night.
Now, obviously, Mr. Davidson is in a difficult position because without waiving privilege in the advice that has been given to his clients, there's a limit to how much he can say about the position. But in my submission, my learned friend's attempt to go behind that is unfounded. It's clear from Mr. Davidson's evidence that careful consideration has been given to the matter, and that if the jurisdiction challenge is pushed off until trial, Mr. Gupta and the companies will require separate legal representation.
Tell me, just so I understand this better, give me an example of the potential. I'm not asking you to reveal confidential information, but give an example of the potential for conflict of interest.
Well, my Lord, I can't waive privilege in relation to the specific issues any more than Mr. Davidson has done, but I can explain how it is that they arise in the same way. I'll summarise here Mr. Davidson's evidence. But the position is this. In broad terms, the claims against Mr. Gupta only arise if the claims against the companies fail, because the companies say that the 2nd, 5th of September letter deprived, if it was effective at all. Of course, the company's primary position is that neither of the September letters had any effect. But if, contrary to that position, the 2nd, 5th of September letter was effective, then its effect was to supersede the first one, so that Mr. Kahlon is not entitled to LTIP. Now, if they're right about that, then the claims against the companies fail. But as a consequence, my learned friend's claims against Mr. Gupta then arise, because then it's said, well, the only reason that the claimant signed the 2nd, 5th of September letter was because he was defrauded into doing so by Mr. Gupta. And so that is, of course, putting it too crudely, because there are many respects in which the companies and Mr. Gupta's interests are aligned. But because of that fundamental conflict, there are certain respects where a particular point arises which would serve the company's interests, but which would not serve Mr. Gupta's. Now, the reason that the proposed direction makes a difference is this. When Mr. Gupta was joined, then in recognition of that conflict of interest, authority to give instructions for the companies has been delegated to Mr. Paul Francis. Now, until the proposal to adjourn everything to trial had been given, none of the parties has suggested that the jurisdiction application should not be determined first in the usual way. And so the companies took the view that although Mr. Gupta may instruct his legal team to take points that are not in the company's interests, the companies could not prevent him from doing so anyway, because if they were not jointly represented, Mr. Gupta would have other lawyers, and those lawyers would take the points in Mr. Gupta's interests on the jurisdiction challenge anyway. Now, in view of the obvious cost efficiencies and other benefits of joint representation, especially given the amount of work that has had to be done, the companies were therefore content to be jointly represented with Mr. Gupta. But my lord, that all changes if the jurisdiction challenge and the trial are to be heard together, because there's no longer any need for, it'll no longer be the position that Mr. Gupta's arguments, whoever are running them, will be heard first. Instead, where there are conflicting points, Mr. Gupta and the companies, in their trial skeleton argument and at trial, will have to put these conflicting positions. And that puts his legal team in an impossible position, They cannot come to trial and argue before lunch for one side, come back after lunch and argue for the other side. And so the position, as Mr. Davidson explains, has been carefully considered. Mr. Gupta and Mr. Francis have been given the opportunity to take independent advice. And the process, the result of that careful consideration and process has been that the legal team have formed the view that they would be unable to discharge their duties to both of their clients if the jurisdiction challenge and the trial were being heard at the same time.
Right. Right.
And the consequence.
What about the alternative suggestion I put to Mr. Hill? Deal with it straight away. No, I don't mean today, but I mean on very short timetable. Yeah, I'm afraid I accept Mr. Hill's point. You wouldn't have 4 days. Seems to me that most of the points have been deployed now in voluminous affidavits and skeletons. If you wanted a further skeleton, I wouldn't stop you. But and same with Mr. Hill. But it could all be dealt with in a week, couldn't it?
Well, my lord, the time estimate is born out of my own recent experience. Having appeared in
I wasn't suggesting an oral hearing. That's what usually prolongs the time.
Well, my lord, we would definitely oppose the idea that this could be done on the papers. It's going to be far too complex, and it's far too important to be dealt with on the papers. These are claims.
I think I have power to direct a summary disposal.
Your lordship does have power, of course, to do that. I'm going to address the case that my learned friend took you to, which doesn't support the proposition that he would like it to support at all. But if your lordship is minded to determine the matter very quickly, then we would say that a hearing of some sort is required. And if that would cause other forms of prejudice, which I'll come on to, and we would resist it for that reason. But if your lordship were against me on that, then we would say it would need to be a day's hearing. And in order to avoid the prejudice to Mr. Gupta of having to get new legal representatives, that would need to happen next week.
Yeah, no problem with that.
My lord, can I nevertheless try to dissuade you from that alternative position? Because in order to cram all of these points into one day, it is going to be.
They don't all need repeating at length. And I'm capable of reading a skeleton argument, and knowing what it is I want to find out orally, if there needs to be an oral hearing.
Yes, my lord. Well, I take that on board. One has to bear in mind, of course, these are claims worth potentially upwards of $100 million against Mr. Gupta personally. And Mr. Gupta is very keen, understandably, that his counsel has adequate opportunity to develop the submissions before your lordship. Now, I entirely accept that if it is going to be dealt with summarily in the next week, then the sort of hearing that might ordinarily be required will just not be possible. And it's for that reason that I fundamentally resist that approach, because that does involve a significant departure from what would usually be the procedure. And in circumstances where, as I've explained, this is all really of the claimant's making, there's just no reason to prejudice Mr. Gupta's right to be heard in the usual way.
Well, I accept that I shouldn't be prejudicing Mr. Gupta, but I don't myself see at the moment what prejudice there would be in having, when I say a summary, a quick disposal of these matters, whether with or without a hearing of up to a day. 4 days would be well exceed any record, wouldn't it, for this type of application?
Well, my lord, I appeared in a 4.5-day jurisdiction application last November. So it's not.
You have form.
Well, before I start getting angry letters personally, I was the respondent in that application. Well, I should say my client was the respondent in that application. But substantial jurisdiction challenges are not as rare as my learned friend would like to suggest, and the issues in this application will be complicated, and your lordship won't really be assisted by just being given a series of references and having to go away and find things in your lordship's own time. But I'm not sure there's a great deal more that I can say on that front.
But that would, I mean, just think, I take your point on the what you would say was the desirability of an oral hearing, and park that for the moment. But if we had a decision within a week or possibly 10 days, that would enable your client to take stock of where he is. Either he's free of the litigation or he's party to it, subject to appeals. But the appeal court can work quite fast if necessary, if it came to it.
My lord, that's right. I have to say I still struggle to imagine how this is going to be disposed of in a hearing of a day. It will be a hearing where things would have to be dealt with in an extreme bullet point form.
Well, if there are skeleton arguments, and I note someone has suggested 50 pages each, not having that.
Well, again, my lord, that was the length of the skeleton arguments in the hearing that I mentioned, and so that's why we've suggested that length.
Probably why it took 4.5 days.
Well, and
sorry, I'm not criticising you, Mr. Trotter. I'm just sort of saying that sometimes these things build on each other, and the longer the skeleton, the longer the hearing.
Well, my lord, in the end, Mr. Justice Foxton criticised us for not giving a longer estimate.
Which judge was it?
Mr. Justice Foxton, as he then was.
Has he gone to Court of Appeal?
He has, my lord, yes.
Right.
So, my lord, that's what we say about the idea of a short hearing next week. In order not to prejudice Mr. Gupta's ability to be represented by the same legal representatives at trial, it would have to happen, I think, next week. And a judgment would need to be given almost immediately, my lord, because otherwise...
By the Monday or Tuesday afterwards.
My lord, yes, that's an enormous ask of your lordship, but the reality of the position is that otherwise Mr. Gupta faces the position where he just doesn't know if he's going to have to go off and instruct an entire new legal team.
Give me one second. I'm just looking at my personal diary. Yep.
Yes, Mel.
Sorry, you were saying
that there is, of course, only 6 weeks until the trial,
which is why it has to be dealt with quickly.
I mean, if it is to be dealt with, it needs to be dealt with very, very quickly, because otherwise Mr. Gupta doesn't know if he's going to have to instruct an entire new legal team, and there's really only so long that can be left.
Is there any? It would be conducive to a quicker disposal if we didn't have an oral hearing, but both parties put in whatever they wanted by way of skeleton argument. I take it against the background that I've read quite a lot of material already on the point, in the terms of the affidavits and the notes.
Well, my lord, the witness statement doesn't have any of the authorities that we'll need to refer to. That all of the preliminary points that my learned friend has made are, in a sense, now additional issues. He has a series of gateway points that say that we can't even make the arguments that we wish to make. We, of course, don't accept any of those. but there is going to be an enormous amount to do. And then the trial skeleton arguments are then due in the week of the 20th of October. Now, looking at the calendar, even if we had a hearing next Friday and a judgment early in the following week, that means that if Mr. Gupta then were required to instruct a new legal team, they've got less than 4 weeks to prepare before trial skeleton arguments are due. For trials involving claims.
Mr. Topper, I take your point about Mr. Gupta's involvement in the instruction of the defendant's team so far, but nonetheless, he doesn't come to this case complete innocent. He knows what the case is about, and is rather better off than some people who are joined as additional defendants who know nothing about it. I mean, he, to some considerable extent, has been involved.
Well, I thought the problem is not so much.
He's issued witness statements and everything like that.
The problem is not so much Mr. Gupta's understanding of the case. Of course, he is aware broadly of the facts and what went on. He was involved in the toings and froings with Mr. Kahlon at the time. The difficulty is that a new legal team are going to have to get up to speed on all of the papers. They're going to have to get up to speed on all of the complicated issues of DIFC law, of UAE law. There's disputes about which law applies to particular issues. There's Mr. Kahlon has served over 100 pages of witness statements taken together.
Yeah.
There's going to be a very substantial cross-examination exercise to be prepared. There are experts speaking to complicated financial analyses that will need to be dissected and prepared. And then there's a 2-week trial. It's not the sort of trial that one would ordinarily be expected to prepare in 4 weeks. And so that is why I say that although I'm making submissions about this idea of a hearing next week as an alternative position, my primary position is that all this is fundamentally unfair, because it creates the problem that not only is Mr. Gupta's jurisdiction challenge going to be determined in an extraordinarily summary way, but also then the trial is potentially going to have to be prepared by a new legal team in extraordinarily short order. And this is not just any trial. It's a trial where Mr. Gupta is facing allegations of fraudulent wrongdoing.
I think Mr. Trotter, one has to be careful to distinguish the disposal of the jurisdiction application from the preparation for trial. I mean, for example, I'm not saying what the outcome's likely to be, but if, for example, I held there was jurisdiction, Mr. Gupta would then have to make a decision about representation, yes or no. Did he, in the light of the day, actually want separate representation? And if he did go for separate representation and those lawyers wanted to make an application to the court about case management, then it's open to them to do so.
I haven't quite understood that, my lord, but
well, for example, it would be open to Mr. Gupta. I'm not saying it'd be successful, but it would be open to him through new lawyers to apply to adjourn the case. Not encouraging that or discouraging it.
Yes. Yes, and so taking it in stages. If the jurisdiction challenge is determined next Friday, then it keeps the possibility open of the trial going ahead on the existing date, especially if the jurisdiction challenge is successful, because Mr. Gupta will no longer be part of the case, or if it's disposed of in a way that means that there's no conflict of interest.
Yeah.
Now, so I adopt that as my alternative position, but I still resist it because the timescale for the determination of the jurisdiction challenge, I say, that's just not realistically going to be sufficient in order to explore the issues in sufficient detail. against the background that I've described. There's no justification for it, but I'm not going to repeat all of that.
And
Now,
you're not necessarily going to have a masterwork of several hundred pages on jurisdiction, but I hope it would be reasonably intelligible and intelligent.
well, I certainly hope it would be both of those things, my lord. Now, I have various other reasons why your lordship's original proposal of a jurisdiction challenge at the trial would not be appropriate.
Well,
I'm not sure.
I don't need to hear those subject to hearing from Mr. Hill as to whether the alternative I put forward. I canvassed with him very briefly the idea of dealing with the jurisdiction point next week or after next weekend. In other words, getting a decision out on jurisdiction within 7 to 10 days.
Before your lordship hears Mr. Hill on that, can I first say something in favour of the proposal that we have made in our letter and in our draft order? Has your lordship seen that?
I have.
Now, the fundamental point here is that hearing the jurisdiction challenge on an ordinary timetable and with the ordinary chance for evidence in response and evidence in reply, skeleton arguments and a sufficient hearing to explore the points in detail doesn't actually result in a terribly long delay. What we've proposed is that the parties use the existing hearing window that we have to make sure the jurisdiction application can be heard properly, and then that a trial date is put in the diary now to avoid any unnecessary delay, which can be effective in the event that the jurisdiction challenge is allowed, or alternatively, one in the event that the jurisdiction challenge is dismissed.
Yeah, I saw that.
Now, that's because the other problem with the jurisdiction challenge being determined now and a trial still being effective in October is that there's just not sufficient time to do the things that would need to be done if the jurisdiction challenge is dismissed. Now, it may be that your lordship says, well, Mr. Gupta can make an application represented by the same lawyers or by different lawyers at that stage. But, my lord, that would involve an adjournment application being made and heard only a few weeks out from trial. And then at the same time, presumably there's going to be directions for incredibly rapid-fire pleadings, defences, replies. We say there would need to be further disclosure. There'd need to be the opportunity for Mr. Gupta to serve any witness evidence he wishes to serve in his capacity as a party. And it all just becomes completely unworkable. So rather than kicking the can down the road for a potential adjournment application at that stage and having any adjourned trial going off much further into the distance, it'd be much more sensible at this stage now to set down a timetable for an orderly determination of the jurisdiction challenge within the existing trial window and to lock in a date for the trial. And we've suggested that a trial could be listed for the first available date after 1st of December. And so we're talking about only a few months delay, but in return, what we all get is a much more sensible timetable. We have a jurisdiction challenge that can be heard in adequate time, and we can ensure that there will be adequate time for everything else that then needs to happen after the jurisdiction challenge if it's not successful. Now, my learned friend says, well, there's nothing else that needs to happen. Everything that's already been done should be sufficient. Mr. Gupta should just fall into line with everything that the companies have done. But my lord, we already know that that's not the case, and pleadings haven't even been exchanged, because at the very least, on limitation, it appears that there is going to be a substantial factual dispute. And we didn't know that until my learned friend's supplemental note this morning that indicated that there's going to be a dispute about the relevant date of knowledge. Now, Of course, there haven't been pleadings yet, so we don't know what all the other issues that might arise are. But when Mr. Gupta, if he is required to do so, serves a defence, it will plead his limitation position. And then when Mr. Kahlon serves his reply, it will plead the various arguments that have appeared in the supplemental note this morning, including, no doubt, a position on when it was that he acquired the relevant knowledge. And in the usual course, there would then need to be disclosure on that issue as to when exactly it was that Mr. Kahlon had the knowledge necessary to set time running. This is, of course, a critical point because it potentially provides a complete defence to the claims against Mr. Gupta. And the suggestion from my learned friend that we should just proceed to a trial in a few weeks' time is an attempt to railroad Mr. Gupta into that trial without any opportunity to sufficiently interrogate the documents on an issue of this kind. And my lord, that's just one example, because we already know, for instance, there is also a mitigation point that has arisen and that's addressed in the confidential annex to Davidson 1. Again, my learned friend says that's hopeless because there's no causation. We don't accept that at all. And I can deal with the merits of that if it's necessary. But the other thing that my learned friend says is it's too late for that to be pleaded. And that's been said in correspondence. And Mr. Gupta, of course, hasn't even pleaded his defence yet. And when it is pleaded, if it is, then there'll need to be a reply and there'll need to be disclosure on this issue to determine whether the claims that are made have been extinguished in full by the mitigation of the loss. So there are going to be steps that are required between the determination of the jurisdiction challenge, if it is dismissed, and the trial. Those are going to be involved steps and not the sort of thing that can happen in a couple of days. And unless machinery is put in place now to deal with that potential problem, then we end up in a position where Mr. Gupta is being required to file defences. There's only a few weeks from trial, and your lordship then has another disorderly adjournment application. And it's not going to serve anyone's interests because then we end up with a trial that's punted off sometime deep into next year. And again, that's what we're talking about.
We're talking about a difference of 3 weeks or so as to assuming if Mr. Gupta's jurisdiction application failed, or are we talking about if it succeeded?
Well, my lord, if it succeeds, then none of this will be necessary because Mr. Gupta won't be a party.
So if it failed, then we're talking about 3 weeks down the road before we can fix the times for things.
That's right. And then we've got to get back into court before your lordship. And then we've got to set deadlines for things. And we're in the throes of preparing for cross-examination. Skeleton arguments are being drafted. There's going to be disclosure requests, pleadings, and so on. It's complete chaos. All of the steps that one would usually take in a trial, all being jammed into a couple of weeks before a 2-week trial and a $100 million claim. It's just bananas. And no one would suggest this in any ordinary case. And the only reason, again, that any of this is necessary was because there's been a late and completely unjustified decision to join Mr. Gupta to the claim.
Well, I've heard you on that. Yeah.
Yes.
That point wasn't made. I know Mr. Gupta wasn't in attendance at the joinder hearing, but counsel representing the first two defendants appeared to have in mind that Mr. Gupta would be, if joined, would be easily slotted into the existing timetable.
Well, my lord,
may have been wrong, but that's the way it was presented.
My lord, I wasn't at that hearing, and Mr. Gupta was not represented at that hearing.
Mr. Paramjit, I think it is.
Yes.
Yeah.
Yes, and it's.
I seem to remember. I haven't checked the audio tape of the hearing, which I'm sure there is one, but I seem to remember pressing him on the practicalities if I joined Mr. Gupta and that the answer came back, whether expressly or by clear inference, that he would just slot into the existing framework.
Well, my lord, in the course of the same submissions, Mr. Frayne-Bell made clear that that Davidson & Co. did not have formal instructions from Mr. Gupta.
Absolutely, I accept that fully.
And so whatever it was that was said on behalf of the companies, I, on behalf of Mr. Gupta, certainly don't accept that position.
Yeah, no, I understand that.
So my lord, the alternative proposal that we have made will be entirely more orderly. A trial date can be put in the diary now to make sure that it doesn't slip off into the distance. And then if the jurisdiction challenge is dismissed, or if it is allowed, then the trial can take place in an orderly way. And that is going to avoid prejudice to Mr. Gupta's interests in having his jurisdiction challenge determined in the ordinary way, and in any trial preparation that might be necessary happening in an orderly way. It will also serve the claimant's interests ultimately, because it will bring the trial on as soon as possible. And so in the scheme of this claim, a few months delay is not worth the disorder that would be required by a rapid fire hearing next week, followed by a series of compressed deadlines and trial preparation becomes unmanageable. So that's what we say about that.
Let me just hear from Mr. Hill on the focusing on timetabling.
Yes, I do have a few points on the wider point. In particular, I just mentioned the question of delay and lateness.
Not really. I don't want any more.
Okay.
blame sharing.
But that's fine. We do suggest that if it's not to be just dealt with at the beginning of trial, this does need to be dealt with probably on paper. I can't do a hearing next week at all. I could do a hearing the following week. But
would you object to a disposal on paper?
No, I wouldn't object to a disposal on paper.
And that would mean that on your side or both sides there would have to be skeletons maybe in by, say, the close of business Tuesday, something like that.
Yeah, we can do that, and probably with some kind of a page limit so everyone knows what target they're hitting.
Absolutely, no more than 20 pages, please.
That's fine.
But bearing in mind what Mr. Trotter has said about the potential for chaos afterwards, depending on the result, of course. But do you want to?
I wonder whether, I think probably both of us would want a little longer. I wonder whether 30 is better, because 20 really is quite tight, whereas 30 gives us a chance, I think, to make sure we've covered everything.
Get some more adjectives in.
We should both try to avoid those.
But what about Mr. Trotter's doomsday scenario, that if we go down this road, and if, for example, there was a decision that the jurisdiction application failed, then Mr. Gupta would be taking separate representation and things would go off the rails?
No, I don't accept any of that. In relation to conflict type arguments, of course, no one can expect him to divulge privileged information, but whenever this sort of point arises, it's usually possible to explain the conflict in broad terms sufficiently for the court and the parties to understand it. But on the learned friend's example he gave, it was unclear that there was any point of conflict. And he kept referring to conflicting positions that being taken and conflicting points, but he didn't really identify it. And on the example he gave, we have a claim, for instance, if the in relation to the 2nd, 5th of September letter, in the eventuality he identified, we'd have a claim against the companies as well as against Mr. Gupta. So even there, it's hard to see that there's a conflict. And he also didn't deal with my suggestion that if there is a conflict, then it can be managed by the existing quite large council team, hiving off one of their individuals who represents Mr. Gupta in relation to that narrow issue. And then when it came to the litigation generally, again, he exaggerated the significance of having separate representation. At trial, inevitably, the lead role can be conducted by the existing counsel team. The idea there's going to be some new counsel team reinventing the wheel and conducting all the cross-examination afresh and considering cross-examination afresh.
So do I take it, putting it very short, that you note but don't agree with Mr. Trotter's doomsday scenario, and you are prepared to take the risk and see what happens?
Yes, if we need to, exactly.
If you need to.
If it is important to maintain the trial date. And just on Mr. Trotter's scenario where the trial date gets moved, I mean, there's a real issue for my client in that if the trial can't happen this year, i.e. in November or December, my client will lose my representation altogether because I go under brief for a huge case in the commercial court as from the end of this year. And so that means we needs to get on this year, and that's why I come back to the starting point on lateness, because it is unfair to suggest that all this lateness has come about as a result of.
Well, I don't want to have that argument deployed. Again, I know the confines of the argument and the sort of points that are made. Well, Mr. Trotter, unless you want to add anything, I'm minded, I'm afraid, to get. I think we've got to deal with the jurisdiction application, and I take your point about the undesirability of having it at the same time as the trial itself. I understand that point and the difficulties it gives rise to, but it seems to me that the sensible alternative is to get it dealt with promptly. What I would propose to do is to order a hearing. Sorry, not a hearing. Order exchange of skeleton arguments by no later than, I would say Tuesday, but if you want Wednesday, I would allow Wednesday of next week with a view to a decision being made by Monday.
I'm grateful.
Or at the latest Tuesday.
I'm grateful.
My lord, I'm not sure if your lordship's reached a concluded view about whether a hearing is required, but certainly I'm instructed to push for a hearing if your lordship's minded to give one in the course of next week.
I'm not minded to, because it seems to me that these points can be expressed in skeleton arguments. But I've already got the affidavit, and the note for this hearing gives me the flavour of it. You can add whatever points are necessary and relevant to the jurisdiction hearing.
I understand, my lord. Well, if that's your lordship's decision, then that is what it is.
And so that was the page limit 30. Did we agree, or did the court?
How many pages do you want, Mr. Trotter?
My lord, I will take as many as your lordship will give us.
I'll give you 30. Happy with that?
That is going to be extremely difficult, my lord. Mr. Davidson's affidavit has been heavily criticised for its length, but if your lordship has seen it, in fact, it outlines. I'm sorry.
I've read it, albeit fairly quickly.
Yes. So
that makes the defence job easier because he's already got his argument set out extensively there, and we don't have the equivalent. So one might think my own friend's in an easier position than we are to hit 30 pages.
I would say if you want to push me up to 35, I'll go that high, but.
Well, my lord, 35 would certainly be welcome. I mean, the point I was going to make about Mr. Davidson's affidavit is that, of course, even though it sets out quite a lot of points, it does so in quite a summary way. And certainly it doesn't deal with any of the authorities in support of those points. So a 35-page skeleton argument is going to be jam-packed. And if that's the case, if that's what your lordship will find most useful, then that is what it will be. But just picking up on my learned friend's point, I ought to clarify that the intention, therefore, on the claimant side is not to serve any evidence in response to the application, but just to deal with it by way of submissions.
Is that right, Mr. Hill?
I think I do need to reserve my position because I want to look again at his argument on limitation in particular and check. But what we certainly will not be doing is serving a response which is a sort of quasi-skeleton. Because one of our criticisms of that first witness statement is it is essentially submission and shouldn't be in evidence. And we certainly would not respond in the same way as a way of trying to sort of increase the length, the effective length of our skeleton.
Can you get any affidavit by close of Monday?
Yes, I'm grateful. Yeah.
But keep it short.
Yes. And
Yes.
In defence of Mr. Davidson, of course, the witness statement made the points. But the purpose is to put my learned friend on notice of the points that will be made in the skeleton. Otherwise, it's impossible.
If Mr. Hill, if you took Mr. Hill to be criticising you, I don't know, but I don't criticise it for that. I do criticise the length of it. But there we are. I'm not going to. No one's going to die because of a criticism about the length.
That criticism certainly won't have such an effect, my lord.
Do you want till Wednesday for skeleton argument, or can you do it by Tuesday? Wednesday gives you a bit of time after whatever affidavit comes in.
Yes, my lord.
Right. So I'll get the anything else that needs to be said at this stage?
No.
My lord,
Sorry.
Oh, sorry.
Mr. Trotter.
It's the hazards of a Zoom hearing. My lord, one thing I would say is that if we're going to have simultaneous exchange of skeletons on Wednesday, then we need to be sure that there's not going to be any new points that we need to respond to. So, for example, my learned friend's skeleton argument supplied this morning proposes an entirely new basis of jurisdiction, relies on a completely new gateway that's never before been ventilated. If something like that were to materialise in the skeleton argument for the first time, then we have no opportunity to respond to it.
You can have, if there's genuine points that haven't been anticipated, you can deal with them by Friday, both sides.
I'm grateful.
I'm not encouraging it, and not another 30 pages or 35 pages. But that's strictly limited to points that haven't been anticipated and have newly arisen.
And I would have thought the working assumption would actually be no more than 10 pages maximum.
Well, it depends on the nature of the new points and the extent of them.
Aim for 10 pages maximum. If there's a good reason for going further, then I'll be the judge of that when it comes in. Ignore the sounding costs.
Thank you, my lord.
So there's that, and there's the two matters we dealt with initially. Any other directions needed at this stage? I think not. I think once we've got the decision on jurisdiction, there may need to be a very quick hearing to decide where we go from there. That can, I think, it's better to have the decision on jurisdiction first, and then we can make some progress.
Yes, I'm grateful.
Yes, it may well be worth trying to get that hearing in the diary so that it doesn't go off too far. But of course, that would require your lordship to form a view about when judgment is likely to be given, which may be very difficult in the absence of the submissions.
By Monday or Tuesday of the following week.
So perhaps a hearing later that week on 25th or 26th.
Well, I imagine that once I issue the decision, parties can liaise with the registry, and we'll only need probably, well, if I say we only need half an hour, it'll probably be 2 hours. But we shouldn't need a very long hearing.
So, I mean, I wonder, it's just at least between the parties. At our end, we could do the 25th or 26th. I wonder if Mr. Trotter could confirm that at least.
What day of the week's that?
That's the Thursday and Friday.
Of the same week as I'm going to give judgment?
Yes.
I'm just checking
I think
those.
I think possibly the Friday would suit me, but not the Thursday. But I can't be certain, I'm afraid. Well, perhaps I can leave it to you to
If that can be
liaise with the
aspiration.
this other aspirational, yeah.
Yes, I'm sorry I missed whether your lordship was available on the Thursday or the Friday, but we
I
could
think you can do both, can you?
we could do the Friday.
I think I could do the Friday. So let's pencil in the idea of the Friday without anyone committing themselves at the moment.
Yes.
Very well, thank you very much. Is
Thank
that all clear? Whether you like it or not, is it clear what's been decided?
Yes, it is to us.
Yes, my lord,
Perhaps
yes.
the two of you can liaise with, be in touch with the registry to make sure the order comes out in the way that is meant to come out, and the order can, if it's any consolation to you, it can undo the direction in quotes that came out earlier yesterday or the day before. I'm sure there's a technical way of doing that.
I'm sure between us we can find a way.
Thank you very much, both of you, for your help. Thank you.